Hey everyone, and welcome to today's Explainer. I'm absolutely thrilled to have you with us. Today, we're diving into something truly fascinating, the core framework that actually protects human dignity within the world's largest democracy. Now, we're looking at the Indian Constitution, but don't worry, we're not just going to read dry legal text. No way. We're going to uncover exactly how this incredible document takes these massive abstract concepts and translates them into tangible, everyday protections for citizens. By the end of this, you're going to have a crystal clear understanding of the fundamental rights that serve as the absolute pillars of liberty. Let's get into it. Okay, let's take a quick look at our roadmap. We're going to start with the Shield of Liberty, move on to fairness and criminal justice, explore the right to life, tackle education as a fundamental right, and wrap up with arrests and preventive detention. Section 1, the Shield of Liberty, setting the stakes. So, to really appreciate constitutional rights, we first need to wrap our heads around the immense power of the state. Think about it. The state has the police, the military, the courts, the power to literally make laws. And yeah, that concentration of power, it's absolutely crucial for a functioning society. But it's also a massive potential threat to individual liberty. Imagine waking up tomorrow in a world with zero rules to check that power. Could the state just lock you up or even take your life just because some official felt like it? Without constitutional guarantees, the terrifying answer is yes. The framers of the Constitution knew they had to build an unbreakable shield against that exact reality. And that shield? It's Article 21. It reads, "No person shall be deprived of his life or personal liberty except according to procedure established by law." Now, it's just one single sentence, but make no mistake, this is the beating heart of the Constitution. It literally sets the overarching theme of our entire explainer today. Your life and your freedom cannot be touched by the state unless they follow very strict, legally established procedures. Section 2. Fairness in Criminal Justice, exploring Article 20. But what happens when someone is actually accused of breaking a law? Even if society thinks you've done something terrible, the Constitution insists that the process of proving it has got to be completely fair. Enter Article 20, which provides some crucial safeguards. First up, protection against ex post facto laws. Basically, the government can't act like a sore loser and change the rules after the game is played, right? They can't punish you today for something you did yesterday if it wasn't a crime back then. Second is double jeopardy. If you've already faced the music once, the state cannot keep dragging you back to court with repeated trials for the exact same offense. Article 20 also tackles self-incrimination. You know the drill. You can't be forced to be a witness against yourself. Now, for this protection to actually kick in, you've got to be formally accused, you must be compelled, and whatever you say has to actually incriminate you. But what's really interesting here is how beautifully the law separates mental freedom from physical evidence. Like we saw in the famous Kati Kalu Ogad case, taking a suspect's fingerprints, handwriting, or blood samples, that doesn't violate this right. The Constitution totally protects your mind from forced confessions, but it doesn't let you hide physical facts from a legitimate investigation. Section 3, the right to life, the evolution of Article 21. Okay, so the legal history of Article 21 features what is arguably the most dramatic plot twist in Indian constitutional law. It completely transformed how freedom is understood. Initially, back in the A.K. Gopalan case, the Supreme Court took a super narrow view. Basically, as long as the legislature passed a law, literally any law, the procedure taking away your freedom was valid, even if it was totally unfair. But then, the landmark Maneka Gandhi case happened. The court entirely flipped the script. They declared that procedures stripping away liberty can't just be blind rules. They absolutely must be right, just, and fair. Suddenly, the state actually had to prove that its laws were inherently reasonable, a real game changer. The direct result of that massive shift is what we call the Golden Triangle Doctrine. The Supreme Court realized, hey, you can't just look at rights in a vacuum. They connected Article 14, which is equality, Article 19, which guarantees fundamental freedoms, and Article 21, the right to life. These aren't isolated islands anymore. They form a combined, interconnected shield. So, if a law restricts your liberty today, it has to pass the test of all three of these articles to be considered valid. By insisting that life actually means a life with human dignity and not just mere survival, the Supreme Court breathed this vibrant new energy into the Constitution. I mean, look at the sheer volume of rights that grew out of this one line. From the Olgatellas case establishing the right to livelihood to the Puttaswamy case cementing the right to privacy, it gave citizens the right to a clean environment, a speedy trial, free legal aid. Article 21 practically became this massive, dynamic umbrella for everyday human rights. Section 4. Education as a fundamental right,
the journey of Article 21A.
So, because life was now viewed as a life with dignity, the courts realized something pretty crucial. You really can't have true dignity without education. Back in 1950, education was just a directive principle under Article 45. It was a nice goal, sure, but not a legally enforceable right. Fast forward to 1992 in the Mahoney-Jane case, and the Supreme Court used that expanded view of Article 21 to declare that the right to life inherently includes the right to education. This bold move practically forced Parliament's hand, and that directly led to the 86th Constitutional Amendment in 2002, inserting Article 21A, and finally culminating in the Right to Education Act in 2009.
So, what does this actually mean on the ground? Well, the RTE Act completely changed the landscape by legally mandating free and compulsory education for all children aged 6 to 14. It outright banned capitation fees and those stressful screening tests, and it even created reservations for disadvantaged groups within private schools. It's a hugely powerful tool aimed at leveling the playing field and empowering the next generation. Now, is it perfect? Not quite. There are definitely still major hurdles like school dropout rates and the ever-growing digital divide. But the constitutional commitment to building an inclusive society, that is firmly locked in place.
Section 5. Arrests and Preventive Detention. The Balance of Power.
All right, here is where we hit the ultimate constitutional tension. How do you balance an individual's personal freedom against the broader security of the entire nation? Let's look at an ordinary arrest first. Under standard criminal law, Article 22 kicks in right away with a super strict 24-hour procedural clock. Step 1, you have to be informed of exactly why you're being arrested. Step 2, you have the absolute right to consult a lawyer. And then, the critical Step 3, you must be produced before a magistrate within 24 hours. The police cannot just lock you up indefinitely. A judge has to officially authorize any continued detention.
But contrast that baseline with preventative detention. It's a stark difference. In an ordinary arrest, the process is transparent, you get a lawyer, and you get immediate judicial review. With preventative detention, however, the state bypasses those standard trials altogether. A person is held not for a crime they've already committed, but based on a suspected future risk they might pose to national security or public order. It hands an exceptionally wide amount of discretion over to the executive branch, and, as you might guess, that makes it a source of immense controversy. To actually facilitate this, there are specific laws on the books. Things like the National Security Act, COFAPOSA for anti-smuggling, laws aimed at stopping black marketing, and the Jammu and Kashmir Public Safety Act. Now, the government's stance is pretty straightforward. They argue these laws are absolutely essential tools to proactively defend the country and stop chaos before it even starts. On the flip side, critics are quick to forcefully point out that these laws severely infringe on personal liberty, they allow for detention without a trial, and they operate with fundamentally weak judicial safeguards. So it remains a highly debated, very delicate mechanism. Which leads us perfectly to our final thought for today. The Indian Constitution really is a masterclass in establishing safeguards for human dignity. We're talking fair trials, the right to life, the right to education, but at the same time, it intentionally builds in mechanisms like preventative detention to ensure the very survival of the state itself. So, I want to leave you with this question to chew on. When it comes to balancing human dignity with the absolute necessity of national security, how much liberty are we as a society really willing to trade? Thank you so much for hanging out with me on this explainer. Keep questioning, keep learning, and I'll catch you next time.